Hello and welcome back to Tenant Law Basics. This is a series of short videos looking at landlord and tenant law in England and Wales in the United Kingdom. I'm Tessa Shepperson and today I'm going to be looking at creating a licence. Now, in previous videos we've talked about the fact that you can occupy a property either with a licence or with a tenancy. That a tenancy is a legal interest in land and that a licence isn't. A licence is when you merely have permission to occupy so that you are not a trespasser. So how can your landlord create a licence and prevent you from having a tenancy? Now, first of all, I should say that there are a number of types of occupation which will automatically be licences. Now, these are lodger agreements, which I'm going to be talking about in a separate video. Service occupancy. Now, this is where somebody lives in a property as part of their job, so they are required to live in the property. So it's not when they've just got a cheap tenancy as a perk of the job, it's when part of their job is actually to live there. So that'll be something like a living carer or a nanny, or also gamekeepers cottages. They have a service occupancy. So those will be licences and not tenancies. Sometimes if you occupy a property because you're a beneficiary under a charity, that will be a licence. There was a case some time ago where a lady lived in an almshouse and she claimed that she had a tenancy. It was held that she didn't because she was a beneficiary under the charity which ran the almshouse. And then also you won't have a tenancy if you are allowed to live there for free, if you have free accommodation, because an essential characteristic of tenancy is the fact that you pay rent. So those are 4 circumstances where you have a licence automatically. But what about if you're living in the property and you're paying rent? When then will you have a licence? First of all, there is serviced accommodation, and this is where the landlord provides services where it's necessary for them to go into the property. And normally this will be cleaning and providing clean linen, towels, sheets and the like. And this is really why if you live in a hotel, because some people do live in hotels, if you live in a hotel you won't acquire a tenancy because hotel staff go in every day and clean it and change the sheets. Well, they may not change the sheets every day, but they'll go in every day and do the cleaning. So if this is part of the arrangement, and your landlord or his staff or agents go in as of right regularly to deal with the service that is being provided, then you will not have a tenancy, then you will have a residential licence. Now, the other circumstance where a landlord can create a licence is when they have the right to move the occupier from one property to another, maybe from one room to another, or maybe from one property to another. Now this is often used by property guardians. Property guardian is where you have a lower rent and you live in a property to look after it. Often they're perhaps industrial properties or something, and you look after it to be sort of like a caretaker. And the property guardian company will often reserve the right to move you from one property to another because, say, their contract to provide guardians for property comes to an end because the real owner wants to use it for something else. So that is a circumstance where you may have a licence because the landlord, your landlord, reserves the right to move you to another property. So those are ways that you can, that a landlord can create a licence. But an important thing to say is that the landlord has to keep it up. It's no good just putting this in the licence agreement and then not doing it. So if a licence agreement says that the landlord will provide services and will come in once a week and clean the room, if the landlord doesn't actually come in once a week and clean the room, then that will not be a licence, it will be a tenancy. Because the facts of the matter is that the occupier has exclusive occupation because the landlord never actually does come in, and therefore it will be a tenancy. Likewise, if the landlord never moves anybody from place to place, and it's something that is never done and hasn't been done for a long time, then if that does go before a court, a judge would probably find that it was a tenancy and not a licence. So, thank you for watching, and I'll speak to you again in the next video.